been there a long time.
Yeah, we've had a low turnover rate. It's been higher the past several years.
Yeah. Well, there's pandemic and there's other things.
Yeah.
Just so you guys know, this,
Yeah, we do.
has been unmuted, so when you say it's hot, just,
Yeah.
just a warning.
Yeah, thank you. Yeah. So, yeah. Anyway, yeah, I think it's just, people moving around, working remotely, doing different things, so.
Yeah.
And they use the whole deal, but, yeah. Well, yeah, we'll have this case, and then, I've not argued any cases in Espanola.
I have
Maybe
either,
community
so-
college, so. We might,
That'll be interesting.
yeah. So.
Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning, everyone. This is S-1-SC-39266, State versus Montano. Can I have entries of appearance, please?
Yes, Ben Lambert's appearing for the state of New Mexico.
And Steve Forsberg on behalf of Ms. Montano.
Thank you. Mr. Lammons, it appears that you have secured 20 minutes for your argument in chief and 10 minutes for rebuttal. Is that correct?
That's right.
All right, you can take it away.
Good morning. I'd like to start with the starting point when this court is talking about interpreting statutes, which is a court's ultimate purpose in interpreting a statute is to ascertain and give effect to the intent of the legislature. Here, by clinging to the plain meaning rule and holding that second-degree DWI homicide by vehicle is a nonviolent offense under the MDA, the Court of Appeals did not do that. And so for that reason, the real questions are, who is going to overturn the Court of Appeals opinion? And is it going to be this court, or is it going to be the legislature by amending the statute? And when is this going to happen? And so I want to give the court 10 or so reasons why it would make sense for the court to be the one to do that, and for the court to do that now. So the first thing I would point out is that since the inception of the EMDA, DWI homicide by vehicle has always been a discretionary violent offense. So we're talking about 22 plus years. So, and generally, implicit repeals of legislation are not favored. And I believe I cited cases in my brief dating back to territorial days for that proposition. And there's just no evidence that this is what they intended to do. And
Let me ask you a question on that.
yes, Justice Vigil.
The Court of Appeals cites legislative history in its opinion.
Yes, sir.
Isn't that indicative or suggestive, at least, of the fact that the legislature did, in fact, consider the EMDA in adopting this new crime of second-degree DWI homicide and not including it either as a per se or as a discretionary serious violent offense?
Well, thank you for the question. It's a good one. They did consider the legislative history, but when you look at it, it's not really persuasive the way that they did it. They refer, and let me get the opinion, let me get the paragraph. It refers to a finance bill, I think, and language in that finance bill that, in essence, says they considered the fiscal implications of earned meritorious deductions. But that really begs the question. The question
Does that not bring EMDA to the forefront? Because legislature is always concerned about money.
yes, you're absolutely right with that. But the thing is, it still begs the question, because the question is, were they looking at it as, well, we consider fiscal impacts of, as a nonviolent offense, or have we considered the fiscal impact as a 50-50 offense. What I mean is a discretionary offense, because you still have EMDA eligibility with either of those. So it's not terribly persuasive. That is
Persuasive to
boilerplate
who?
language.
Persuasive to who?
Well, I would submit that it shouldn't be persuasive to the court, because that phrase is usually boilerplate language. You know, when I've done bill analysis and looked at those things, it's the court is considered, I mean, the legislature or this fiscal committee is considered the impact of this legislation. So that's language that they use. But that language would still be there even if it was a legislative oversight, which is what the state's position is it was an oversight, but you would still have EMDA eligibility, and that fiscal committee would still come out with a report. I wanted to, I
hate to keep interrupting, but legislative oversight is really not the test. The test is whether or not there was a mistake or an absurdity which the legislature could not have intended.
right.
And with the EMDA right there in their face, in the legislative analysis of the bill, how can you say that this is something they could not have intended?
There are several reasons. You know, like I was, you know, I kind of began with saying I think there's at least 10 reasons, you know, that we need to look at. But one of those is when you talk about legislative history, what has the structure of the EMDA been over its 23-year history? And what I want to suggest to you, Justice Vigil, is that, and to the rest of the court, the way it is structured, it's structured so that there's an inverse relationship between an offense's degree and the eligibility for EMD, right? So if I give you a quick example, if you look at first-degree kidnapping, it's a per se violent offense. If you look at second degree, it's a discretionary violent offense. If you look at first and second degree criminal sexual penetration, those are per se violent offenses. But if you look at third and fourth degree for the same offense, those are discretionary. And the same is true for criminal sexual contact with a minor. The second and the third degree felonies are per se violent offenses.
So, Mr. Lamons, I agree with you that generally the structure of the EMDA is hierarchical. But there's exceptions to be found to that structure that have been blessed by the appellate courts in New Mexico. I think State versus Bennett is probably the more complicated example for your position, because there doesn't seem to be a significant reason for departure on third degree aggravated battery against a stranger versus a household member.
Right.
But this court said, or not this court, the Court of Appeal said,
That's a great point. Can I respond to that?
Of course.
It's a great point. It wasn't this court, because this court, in my humble opinion, at least from the cases the Court of Appeals has cited, has done a much better job of ascertaining the legislature's intent regarding the EMDA than the Court of Appeals, and I'll tell you why. And it's a perfect example. The legislature didn't like that decision. And how do we know that? They amended the statute. So if you look at the 1999 version, the 2003 version of the EMDA, and those versions, it's not in there, like the Court of Appeals said. But the response to the Court of Appeals opinion was to amend the EMDA and add third degree aggravated battery against a household member to the EMDA. And so that's a signal that the Court of Appeals didn't ascertain their intent and didn't give it effect. And so this dovetails
But
into,
didn't the Court of Appeals exercise appropriate restraint in saying, we're not gonna reach this issue because this is fundamentally an issue for the legislature to declare as opposed to the court?
and the state's position is no. I mean, if the goal is to ascertain intent, the problem with the EMDA is that, another problem is the structure. Your statute would be 100, I don't know, 50 pages long if you had to list every felony offense. In other words, it only lists, there's 4 categories, right? What I want to call, it's not labeled as such, but I'll call it an ultra serious offense. That's first degree murder because it's mentioned. It's just not labeled that way. And it says you don't get any EMDA for that. Then you have per se, and the second degree involuntary man fall into that. And then when you step down to fourth, that's a non-violent offense. So that relationship in terms of degree is there. And even though, I don't know, I'm getting a little lost. I think it's the way it's structured. In other words, the fact the legislature didn't add it means either that there was an oversight or they didn't intend to add it. But it could mean either of those things. And that's why it's necessary to go to the next step.
So can I ask you, and it may not have any bearing on this analysis, but do you think TFOIA has any bearing in support or against your argument? And I ask that because in TFOIA, this court went beyond the life sentence language in the EMDA
Right.
to say, well, first degree murder charge of a serious youthful offender, even though it's not explicitly in there, we're going to not consider it a nonviolent offense.
Well, I can't really speak to that, but the notion that this court can never add language to affect the intent of the legislature, we know that's not true. I can go back to Cortese, an 1893 case, so territorial case, and that was a blue law case where language about buying and selling of liquor, I cited it in one of the briefs, but about, blue law case about, there was language about not being able to sell or buy liquor on Sundays in the early version of the statute. It was taken out of the later version of the statute, and the territorial Supreme Court said, no, that language is in. They didn't mean to take it out. So I think that's part of the obligation. And I want to talk about another limitation on the plain meaning rule. I mean, yes, it's the starting point.
But where do we draw the line? If we hold that the legislature did not intend to eliminate this language, where do we draw the line? Because the EMDA, the thing that Bennett that I found so convincing is it's not only the charge, it's the citation to the statute. So there's really no ambiguity. And when do we start, there's crimes created
Right.
all of the time. When do we start saying, oh, the legislature intended it even though they didn't put it in. The legislature did not intend to remove it even though they didn't put it in. Just
Well,
wondering where we draw the line.
I would submit, Justice Zaborn, that it's not in this case, and here's the reason. Think about this conceptually. It's fine to give to accord the plain meaning to language in a 2015 statute, right? I mean, but it doesn't tell you anything about the legislature's intent concerning a crime that doesn't yet exist. And what I would point out to the court is second degree homicide, DWI homicide by vehicle didn't exist until 2016. So
Did
Court of
that?
Appeals, can I just
Go
finish my
ahead,
thought for a
sure,
second?
please, I apologize.
And then I'll be right there. So the Court of Appeals, it's like, by just using that rule, it reflects a misunderstanding or just an oversight on the Court of Appeals part about how legislatures work. They don't consider and they don't allocate earned meritorious deduction eligibility for crimes that don't yet exist.
The crime
What they do
existed.
is they create the crime, and then hopefully, if they're mindful of the EMDA, they then assign it a classification.
The crime existed, they just increased the punishment. Vehicular homicide by DWI has been a crime for
Well, right,
decades.
but that's a different crime, and that's how the problem is created. It is a different, it's literally second degree homicide, DWI homicide by vehicle, and it used to be third degree. So when you look at the statute, if that had been the intent, is to just make it a nonviolent offense, look at how the current version looks. You know, it just says third degree homicide by vehicle. So they could have made that clear. They could have said third degree reckless homicide by vehicle. And then we would know, and then we wouldn't be here. But that's the limitation of the plain meaning rule. So if that's the only rule of statutory interpretation in your toolbox, that's the hammer, then everything you come across is going to look like a nail, and you're going to, in some cases, misconstrue the intent, and that's the stated purpose of statutory interpretation. But
Getting back to, Mr. Lamb, getting back to Justice Zamora's question, where do we draw this line? I mean, this is not the only violent offense, as the Chief Justice pointed out, that's not in the EMDA. There's the household member statutes, there's the statutes related to assault or battery on a referee, on school employees.
right.
Do we need to start reading this language into those statutes as well?
No,
Where do we draw that line?
Well, it's a good question, Justice Vargas, but what my response is, no, you don't, because you have to look at the specific history of how DWI homicide by vehicle came to be a second degree felony, not a third degree. It's the naming strictures, I don't know the word I'm looking at, that they use. In other words, because there was no such thing as second degree homicide by vehicle, there was no such offense, the legislature didn't need to spell that out, because all homicide by vehicle was a third degree felony at that point. And so this is what points to that. And, you know, I mean, all legislatures make mistakes, but I think we have to consider the state that we're in. I mean, we're one of only, I think, 5 citizen legislatures, and if there's only a general legislative session in a year, there's only 30 days in even years and 60 days in odd years. And this legislature has a tremendous amount on their plate. And so there are going to be oversights like this, but it doesn't fit. Like if you look at the structure, there are no cases where the higher degree of felony, if you look at the structure of the EMDA, there are none where the higher felony actually drops lower in the classification. But this is the first time Court of Appeals opinion, if it is left intact, which I don't think it will be, you know, I think the legislature will change it if this court doesn't, but it'll be the only time
Well,
that the higher offense falls all the way into nonviolent.
so prior to 2016, is it, when the second degree homicide?
Yes,
Prior to that, homicide by DWI and homicide by reckless driving
Mhm.
were treated the same,
Yes,
both for sentence and under the EMDA,
yes,
correct? So then it comes to 2016, the legislature on purpose makes a distinction between DWI homicide by DWI,
yes,
and homicide by reckless, correct?
yes.
Now, and my ultimate question to you is this: isn't there a basis for distinguishing one form of homicide from another form of homicide in terms of not only sentence, but also EMDA? because reckless driving can be committed with recklessness in the face of knowledge that one's acts are reasonably likely to result in serious harm. That is the definition of how a judge is defined a discretionary serious violent offense under EMDA. But you don't have to commit homicide by DWI with that same state of recklessness. So
Yes,
the
I
bottom
agree with
line
that.
is, isn't there a reasonable basis for treating the two crimes differently in terms of not only sentence, but also EMDA?
It's a great question, and I'm gonna say, no, there's not a reason. Here's why I say that. Again, I go to DWI, homicide by vehicle, has been a discretionary violent offense since the act's inception in '99. You know, the modern way of creating eligibility for EMDA. And so if that were the case, then they wouldn't have classified it that way then. They would have said, well, there's no recklessness involved. The mens rea didn't change for DWI homicide by vehicle between 1999 and 2016. I mean, it didn't. So if I can, so I hope that answers your question. I wanted to talk about one more thing. Well, I've got 2 minutes left. I'm gonna have to wait.
You have no minutes left.
2 seconds on
Yeah.
Thank you.
Thank you, Mr. Lamb. Mr. Forsberg.
May it please the court and opposing counsel. I would suggest to this court that this is a very straightforward and simple case, but underlying it is a tension in New Mexico law about how and whether to apply policy analysis when interpreting statutes. The EMDA statute defines a violent offense as one listed in the EMDA statute, and it lists all of the offenses that are covered. It also says that anything not listed is not a violent offense. I mean, that's very straightforward to me, and it's unambiguous, and I believe the court can simply say, that's all the court needs to do.
Why isn't it ambiguous in terms of the hierarchical nature of the EMDA to have something that's has a greater penalty falling outside of the EMDA when everything else is kind of lockstep?
I would say that the language of the statute is unambiguous. I think what the state is conflating is the logic of a decision as opposed to the text of what the legislature actually enacted. There is no requirement that the laws the legislature enact be logical or follow any disciplined structure.
You said it.
Yes, I said that so that you don't have to, Justice Bacon. But it's quite true. And Oliver Wendell Holmes, the famous judge, once admonished a lawyer that logic is not the life of the law, but experience. And it's true. Our Constitution doesn't mention a requirement that laws be logical. And as attorneys trained in logical analysis, I think attorneys and judges are often frustrated by what they see the legislature do because it's not perceived as being logical or orderly or organized. But that is the system that we have. If this court decides to look for policy reasons, I would suggest, one, I gave a lengthy explanation in my brief in chief as to why, if the legislative intent was to increase the penalties, they succeeded. What the state is complaining is that they didn't increase the penalties enough. But I would suggest there's another reason why this outcome may have occurred that is entirely plausible. One person on the Criminal Justice Committee said, yes, we should make this a more serious crime. Another person on the Criminal Justice Committee said, no, I don't think that's a good idea for whatever reason. And the chairman of the committee might have said, let's meet halfway. We'll make it a more serious crime, but we just won't, but we'll permit the person to earn 50% good time. That could have just been a simple, short conversation in the legislature, a type that I'm sure happens all the time, and that could explain why the statute is this way. If this court is to go around and start changing statutes to accord with the judiciary's idea of what is logical and what should be done, I think would be to overstep its role completely. And I believe would create more problems than it solves.
You recognize, well, I guess you will concede. And the answer is we just have to live with it. The absurdity in the same offense before the statute was filed and after. I mean, I tried to calculate this and perhaps you can help me. But a judge under the new offense would have to sentence at the top, the very top of the, I'm not using the term guideline though, the top of the range, in order to meet the penalty that existed under the old statute. That rings absurd to me.
Well, Justice Thompson, first of all, I would suggest that trial court judges are quite aware of how their sentences are interpreted and applied by the Department of Corrections. And I would not be surprised. A criminal court judge wants to do that, they will assign the maximum sentence. Criminal court judges, in my experience, alas, as a defense attorney, are often quite willing to give the maximum sentence. So yes, a judge can apply that lengthier sentence by sentencing the defendant to the maximum sentence. But something even more fundamental I'd like to get to is that absurdity, legally speaking, is a much more restricted term than in general usage. People like to say, this is absurd, that is absurd. Legal absurdity means that there is no plausible explanation. And as I've said, there are several plausible explanations for why the legislature chose to write this statute the way they did. And one of them I suggested is it's just a compromise. It's a messy compromise. And that may rail against our desire for things to be neat and orderly and follow a system, but that's the way the legislature operates.
So can I ask you, and it may not, I'm kind of debating it in my own head, but I'll ask you. The Tafoya case, we read language that wasn't in there. We said a serious youthful, like the subsection G talks about life imprisonment, that a serious youthful offender can commit first-degree murder and not be required to be sentenced to life imprisonment. However, first-degree murder is not listed as an SVO, and I think in that case, we said, well, it's not listed as an SVO, but come on, I mean, doesn't mean they should get 50-50 good time automatically. So I guess I'm wondering, this would not be the first time where we added language that, and granted, that's a lot more serious. But we did say, of course, first-degree murder's an SVO, even though it's nowhere in the statute.
Yes, Justice Zamora. And I would suggest that what you're in effect saying is that the first time the court has ever not strictly followed.
Yes.
The courts are always making exceptions. And I understand, a lot of judges don't like to hear that. They like to think that the law is just in concrete and everything is always done according to some preconceived ideal. But the court is always making exceptions. And there is an underlying tension that I discussed earlier in New Mexico jurisprudence about how to perform statutory construction. Because there are many cases where the courts, the Supreme Court and the Court of Appeals have followed what in my brief in chief I pointed out was the federal model, which is the text is the best indication of what the legislature wants to do. And if the text is unambiguous, you stop. There's no need to go any further. However, there is language sometimes used in New Mexico cases that says the intent is the intent of the judiciary is to enact the intent of the legislature, and therefore you should look at the policy and history, et cetera. And there is a clear tension between these two schools of thought. And it's not, I don't believe this is limited to New Mexico. Judges throughout history have disagreed about to what extent and when this court can go in and ostensibly try and fix problems with legislation. And if this court doesn't want to reach that underlying issue, I would suggest that a very straightforward way to deal with this case would be simply to quash cert. The Court of Appeals decision, I think, is correct. And I think it's correct using either process. And I would just point out, I believe it was Invest, in my brief in chief, I pointed out, this court said that the statute is unambiguous. Our analysis can end then, but out of thoroughness, we will do a policy analysis.
Mm-hmm.
And that kind of language drives appellate attorneys up the wall.
It's squishy.
It is, very much so, Justice Bacon.
Yeah.
And I don't know if this court wants to or can reach that underlying issue and maybe clarify the New Mexico standards for judicial review of statutes. If it can't, I would suggest this court just simply quash cert and leave the Court of Appeals decision in place.
I don't there's something about what you're saying that rings true to me, Mr. Forsberg. I am troubled by the fact that we see it time and time again from the Court of Appeals that the answer is stop at step one, but then we're going to go to step two anyway and start trying to suss out legislative intent. And here, to me, that's highlighted in a particular way that at least troubles me, that the Court of Appeals' reliance on an FIR is what they use to discern legislative intent. And I spend a lot of time in that crazy building down the street, down the parking lot, and the FIRs routinely are wrong. I mean, just flat wrong. And so how are we discerning legislative intent from an FIR, and is that fair?
Yes, Justice Bacon, I would point out that as a jurisprudential matter and in political science circles, some people would argue it's a mistake to talk about legislative intent. The legislature is a corporate body made up of a lot of legislators who are often intending things completely at cross odds. And that's one of the reasons what we get out of the legislature in actually passed legislation is often somewhat illogical or doesn't appear to fix the problem that we think it was aimed at. But that's just the nature of the process. New Mexico doesn't have, and then there's also a debate which rages in the US Supreme Court about what exactly is legislative history. As this court has recognized, New Mexico does not have a system like the federal system where the US Congress actually files committee reports and other forms of documentation that actually explain statutes and give background. Our legislature basically operates on the premise that you get what you get. There is no official legislative history. So I would suggest that relying on legislative history or looking into it is very problematic. And that is one of the reasons that the federal courts, even though they have that system and all that legislative history, have adopted a policy of if it is unambiguous, we stop.
And don't you think, that troubled me as well. I had the same issue with the Court of Appeals opinion because of relying on the FIR, not only in this particular case, but in future cases. I don't think that's a good habit our court should be getting into. To me, the Bennett analysis actually seemed more appropriate. It just kind of said, this is the language, the statute's here, and we end our analysis there. It's up to them to fix it if it was an oversight, but we can't say that it was. Do you think the analysis could just end with the plain meaning in this case and not go any further?
Yes, Justice Zamora, as I said, using either method of analysis, either stopping at an unambiguous language or if you just want to say, we'll start with policy analysis, I believe even on policy grounds, this case can be won by the defendant. As I said, the question for legal absurdity is not to discern what the legislature actually intended, if it intended anything. The question is there a plausible explanation?
So I think the language used by my colleague, Justice Feehill, was the legislature could not have intended this result.
Right.
Is the test.
And I think we've demonstrated in this case that the legislature could have intended this result. As I said, it could have been a simple compromise between people who disagreed about a statute, and that when they created the second degree homicide by vehicle by DWI, there was just an agreement that, okay, we'll make this more serious, but we'll still leave them the 50% good time option. And as I said, it would be very difficult for this court to ever know, let alone rule on or analyze those kinds of decisions based on the record in a case on appeal. So this court would be actually interfering with the process of legislation, which is often a process of compromise and a process of involving, very detailed types of agreements that are often intentionally not made public. And yet this court would have to come along years later, perhaps, and try and recreate exactly what the legislature was doing or what agreements or conversations were had in private. And I don't think it works. And the case law makes clear that the court shies away from doing that sort of thing. The best language of what the legislature does is the plain text. And it is assumed that the legislature knows the law when it enacts law. So the fact that the legislature did not go out and amend the EMDA at the same time as it amended the homicide statute, I've kind of lost my train of thought, actually, to be honest.
Well, it seems to me that homicide by DWI can be treated for very good reasons as different from homicide by reckless driving.
Absolutely, Justice Feehill. Homicide by DWI is often associated with alcoholism, a very common problem, but one that is treatable. And there may have been a decision by one or more of the legislators that by giving 50% good time, which has to be earned, and the way a person earns good time is by participating in programs and treatment as prescribed by the Department of Corrections, that they are incentivizing people with serious alcohol problems to go to treatment and to comply, as opposed to just going to prison and saying, well, I'm stuck here, I'm not going to do anything, nothing's going to change. So the giving of good time could be seen as an incentive for prisoners to work hard at correcting their problems, as opposed to simply being warehoused. And that is an argument, a very good argument, always, I think, for reducing or for making sure that defendants and convicts can earn good time, is because it has to be earned and it incentivizes them. So the idea that the legislature just automatically wants everyone in prison to do the maximum amount of time, I think is incorrect. I think sometimes the legislature wants people to do less time in prison, but make it more productive and actually perhaps fix the problems that got them there. So as I was saying, I feel this case is very straightforward. And if this court simply chooses to say that the language is unambiguous and the legislature has spoken, I believe that is a sufficient reason to rule. Now, I also understand the judiciary is often uneasy doing that. And one reason is that while that may be a legally sufficient reason to reach a decision, courts often write their decisions for a wider audience. And courts don't like to just say, well, we are just here to enforce what the legislature says. They like to explain and justify why not only it's the legally correct answer, but it's also the policy correct answer. And I understand that there is once again disagreement among justices and judges about, you know, how often the court should do that and what is the role of decisions and how that interplays with statutory construction. But I would simply suggest that a lot of times what the courts call policy analysis is really just justification for reaching a decision that the court says it would have reached anyway. In other words, the decision is not just legal, it's a good idea.
This argument was answered in McDonald, where the court said, we understand your policy argument, Mr. State, that an agreement to kill somebody results in death is just, the person is dead, regardless whether it's a result of an agreement or an act. And therefore, we understand your policy argument that this should be the same, but the court clearly said unanimously in McDonald, we're not going to consider that policy.
Yes, and I
It's not our purview to do that.
I believe that is the correct position, Justice Vigil. However, in practice, you know, the courts don't always hew precisely to that standard, and I understand that. And I'd also point out that, as I did in my brief in chief, there is always an exception, almost always an exception that the judiciary leaves itself. It doesn't like closing a door permanently. It likes to leave a little crack for unforeseen problems. And the absurdity exception is one of those. As I cited in my brief in chief case explaining that, like all exceptions, it can be abused. And sometimes it's very tempting to just go around and say, well, this is absurd, that is absurd. But every time the court does that, it undermines the legislature's power. And it involves the judiciary in issues that its role is not to play a part in. So once again, I apologize. I've kind of lost my train of thought. I'm going on too long, I'm sure. But there are always exceptions, and it is the self-discipline of the courts, the self-discipline of judges that prevents them from falling into the trap of making the exception the rule. And I think that's the danger of the state's position here. The state says, well, there is an exception called absurdity, but we're going to make the exception the rule because you can argue from various principles that almost any legislative act is absurd. I'll just give a recent example that this court may be dealing with. You know, I won't analyze it or anything, but medical malpractice. I am quite confident that there are parties who would be more than willing to come into this court and argue that whatever the legislature did was not logical, you know, was absurd for one reason or another. Very contentious issue, very hard fought, a lot of hard feelings on all sides, I'm sure. But this court's role is not to act as a super legislature and fix mistakes of the legislature. The court's primary purpose is to ask whether what the legislature did is lawful, not whether it is logical or the best thing. So just to briefly summarize, I've laid out the reasons why I believe this case is very straightforward and simple. Even if you do the policy analysis that the state asks, I believe a policy analysis would still support the finding of the Court of Appeals. So I would ask that this court, if it does not quash cert, to reach a decision in favor of Ms. Montano in this case. And if it so desires, this court can attempt to clarify for everyone exactly how statutory construction is going to be done, and perhaps clarify the limitations on policy analysis and the consideration of legislative intent. So if there are no further questions, thank you.
Go ahead, Mr. Mayor.
Thank you. Well, the state's not asking this court to be a super legislature or make policy decisions. I want to address.
Well, let me ask a super legislature question.
Uh,
Are you asking us to construe the statute to make homicide by DWI a per se or discretionary? And on what basis would we distinguish one from the other in coming to a conclusion that it's this or that?
Great question. Discretionary is the answer because that is the legislative history. That is the 23-year history of DWI homicide by vehicle. And there is no room at this point to say that it's a per se violent offense. I want to talk about the McDonald case, which Justice Vigil raised, but I also want to talk about an earlier case. And this has probably some of the most often quoted language from this court. It's Hellman. New Mexico courts must exercise caution in applying the plain meaning rule. Its beguiling simplicity may mask a host of reasons why a statute, apparently clear and unambiguous on its face, may for one reason or another give rise to legitimate, non-frivolous differences of opinion concerning the statute's meaning. That's 1994 opinion of this court, XRL Hellman versus Gallegos. They go on to explain why that's true so one part of the statute may appear absolutely clear and certain to the point of mathematical precision, lurking in another part of the enactment or even in the same section, or in the history and background of the legislation, or in an apparent conflict between the statutory wording and the overall legislative intent. There may be one or more provisions giving rise to genuine uncertainty as to what the legislature was trying to accomplish. And I believe that is this case. And this court has often started with the plain meaning rule and said it's not enough to truly ascertain the legislature's intent. In the double jeopardy arena, this court has often said we've got to look at lots of indicators of legislative intent. There's a case called Cleve, one of my favorites. It's the cruelty to animal statutes. And that was a case where the court could have said an animal is an animal. I mean, that was the wording in the statute. But they looked at the wildlife statutes, they looked at the legislative history, they went beyond the plain meaning, and this court said, no, under that statute, it means animals, domesticated animals or animals reduced to captivity. So that language was read in, and I think the state lost that case because the state was on the losing end of that one. But the point is, it's not just to correct an absurdity. The Court of Appeals, in this opinion, recognizes it can also be done. You can go to the other rules to correct a mistake, and they quote Bennett for that. I want to talk about McDonald briefly because I don't have a lot of time. Justice Vigil, you mentioned that case. That was a case where this court got it right in terms of the EMDA and whether conspiracy to commit armed robbery was or was not. I can't remember if it was discretionary per se, but it was not one of those. It was so this court held it was a nonviolent offense, and it got it right. But what I want to point out is that for initiatory crimes like solicitation, attempt, and conspiracy, it's different. None of those have ever been designated as discretionary or per se violent offenses under the EMDA. So to reach that decision, this court had to look at the legislative history. Same thing in Loretto, a 2006 case that I believe, of the three cases that the Court of Appeals relies on, I want to point out that Loretto is attempt to commit criminal sexual penetration, another initiatory crime. And so this court said, no, we don't see a legislative history of initiatory crimes being part of it. They couldn't point it to any. None had ever been part of, either a discretionary or a serious violent offense under the EMDA. So that's a situation where this court didn't stop at the plain meaning rule, as respondent urges the court to do here. But if the court's truly going to try to ascertain the legislature's intent, it can't really, the state's position is it can't really stop at the plain meaning rule, especially when the plain meaning rule is being applied to a 2015 statute when the 2016 crime didn't exist yet. And so I want to address another of Justice Vihill's concerns, and maybe the rest of the court's concerns, but you mentioned the difference between reckless and DWI homicide by vehicle. So one of the ways you get insight into the legislature's intent is to see how the legislature has treated reckless homicide by vehicle and DWI homicide by vehicle in other contexts. And so I want to come to State versus House, a 2001 opinion of the Court of Appeals. But there the Court of Appeals treated DWI homicide by vehicle as the more serious of the offenses. And what was happening in that case is the defendant was convicted of 4 DWI homicide by vehicle counts and there were 4 reckless homicide by vehicle convictions, all arising from the same criminal episode. So this is Gordon House, defendant in this one. And what he wanted the Court of Appeals to do is he wanted it to vacate the DWI homicide by vehicle counts rather than the reckless homicide by vehicle counts. But what the Court of Appeals did is they looked at other aspects of this, and they said, well, wait a minute. The legislature views DWI homicide by vehicle as a more serious offense because it has attached sentencing enhancements to that offense that it did not attach to reckless homicide by vehicle. And so this was, let's see, it's based on a provision that permitted the sentence of a DWI homicide by a vehicle offender to be enhanced by 2 years if the offender had a prior DWI conviction within 10 years. So the steps the legislature has seemed to be taking on the DWI front is to elevate and take that crime more seriously. And, it doesn't do that if we then give with one hand and we increase and say, oh, flip the EMD statute upside down and then switch that. I mean, it's too much work for the legislature to do that and come up with a 1.5 year difference. It's just, it doesn't make sense. And even the legislature, even the Court of Appeals here recognize it's not, the statute doesn't, it doesn't have to be absurd. This court has the power to correct if it's a mistake. And so that's where it is. It's the legislative history and the framework. And if you look at the cases they cite.
Do you agree that it has to be a mistake that they could not have intended?
Yes, I do.
Isn't that what the case law says?
Yes. What Bennett says is the legislature appears to have carefully structured the EMDA. And this careful structure is that hierarchy of offenses and that inverse relationship. And this would be the only offense where your classification is higher, second degree, but then it flips you all the way out, all the way out of the EMDA.
But would you agree with me that when the legislature created homicide by DWI as a second degree felony, they created a new offense?
Yes, it's
a new
different
offense. It's a brand new offense. It's not amending this or amending, it's a brand new offense.
And that's why the plain meaning rule can't be applied in a vacuum without resorting to other rules of interpretation. Implicit repeals are not favored, and this would be an implicit repeal of a 23-year-old designation.
No, you're saying, you're conflating this, and I hate to use the word complaint, as my colleagues well know, but you're equating second-degree DWI homicide with third-degree DWI homicide. And you just agreed with me that when they created second-degree, it's a brand-new offense. So you can't equate a new offense with an old offense. I think is the flaw in your logic.
Okay. Last point I'd make with the 17 seconds I have.
You'd have no time left, sir.
Oh, this is over. Yeah, I'm
Yes.
sorry. Okay. Well, I was counting up, not down. All right.
I understand the inclination.
Yeah. I
Thank
appreciate
you,
it. Well,
Mr.
thank you.
Lammers. Thank you for your argument, counsel. The case is deemed submitted for decision at this point, and I'll get you a decision as soon as practicable. Thank you.
Oh, it's all over but the waiting.
Yeah. Well, we'll do it again on the 3rd.
Yeah,
Let's
let's
do it.
see you up there.
Do it at Northern New Mexico Community College.
Yeah, I'm gonna spend the night up there.
Yeah. Prepare ahead.
Well, yeah, just to enjoy the Ranger of Espanola.
Yeah. Well,